All right. Well, welcome folks to today's session that we're going to be focusing on with legacy planning, just common and basic fundamentals when planning an estate. This session has been overwhelmingly attended. And after the last session, the last quarterly update, it was brought to our attention that this is one that was highly requested. So today, the goal is to speak for about 45 minutes or so, 45, maybe an hour. There is a lot of information. This session will be recorded. So the good thing is that there will be a copy of it that will come out likely later this week, if not early next week. Just as a side note, although we're recording this, obviously we're not recording any of the attendees. So you'll just get my comments then along with the slides. So I'd ask that anybody that has questions, I will keep it open after I finish here for some questions for about 5-10 minutes. If you do have any questions, please put them in the chat box or the question and answer box, sorry. And I'll make some notes as we're chatting and we'll go from there. So I guess without further ado, I'll get going. First things before I jump into it, I just want to thank everybody for joining me here on a Tuesday afternoon. It's an important topic, one that is not overly being enforced or put in place by a lot of Canadians, unfortunately. So hopefully today you'll find some useful information that will apply to you. There might be some in here that doesn't apply, but again, I could have probably chatted for 2 to 3 sessions on different aspects of estate and legacy planning. But again, I'm trying to address some key items. We'll talk a little bit about tax as well. So just the agenda today, as we try and get through here. So number one is we're just going to talk about this whole great wealth transfer about what's happening here, probably over the next decade or 2 decades, or as assets pass from one generation to the next. We're going to talk a little bit about how prepared are Canadians, perception versus reality. So we'll look at some of the statistics out there. And unfortunately, there's going to be a few that will be applicable to those that are actually on this call today. We'll talk a little bit about how assets are taxed come estate time. Again, everybody on this call might have a little different situation, whether having a corporate account, whether having registered plans, RSPs, maybe RIFs or LIFs. So we'll talk a little bit about a high level example, just to kind of get an idea. We'll talk a little bit about how CRA takes a big chunk out of your estate and also some ideas about how to minimize that. And then I'm going to finish it up with just 9 estate planning mistakes, some of which we'll cover today, but some which will be new as well. So let's look at the wealth transfer just by numbers. Okay. So when the assets are flowing from obviously parents to the kids, we're in a situation, we're at a time today that it's going to be an unprecedented period of time where we're going to see a significant amount of wealth passed down to beneficiaries, most likely kids or other family members. Okay. And inheritance, what they forecast, it could hit as much as $1 trillion over the next decade. And that number seems pretty unrealistic when you kind of try and wrap your head around it. But when you just think about even just real estate and the growth of real estate here, especially in Vancouver and Toronto and other areas across the country, think about the amount of wealth that will actually pass maybe from you to your beneficiaries. Okay. Factors that will significantly impact the numbers, not only today, but ongoing, obviously, is economic growth. We're obviously coming through off a period of time here in 2022 where we actually had economic contraction, but we're in a stage now where we're starting to see some movement on the upside. And again, we're on the cusp, I think, of the next kind of bull market as we work through some of the numbers and inflation numbers and so on. Obviously, stock market. So for people that actually own companies, whether in individual stocks, ETFs, or other wrapped accounts, obviously the growth on those assets over time will only magnify the amount of money that will actually transfer between generations. And then real estate prices. Obviously we're in a high interest rate environment, but for those of you on the West Coast, what we're seeing is that the real estate prices have really hung in there despite borrowing costs going up. So I would anticipate real estate to continue to move upwards and onwards over the next a number of years or for the foreseeable future. And then if you're a business owner, again, regardless of the size of the company, if you have the ability to sell it, 70% of private company owners plan to sell or pass on their business in the foreseeable future. So probably over the next decade or so. So although this might not be an estate-driven wealth transfer, it is a wealth transfer amongst families, typically to the next generation. So when we look at, different generations about leaving an inheritance, there's a recent Merrill Lynch survey, and it talks about 57% of the individuals that actually responded to that survey, age 55 and older, which for us, that the folks that we deal with, those are the individuals that are, 10 years to retirement or they're into retirement. They said that leaving an inheritance was the right thing to do for their children. Okay, whether you agree or not, this is what 57% of the individuals said. Okay, 55% of millennials, meanwhile, said it's a parent's obligation to leave an inheritance. So I don't know if that's how your kids think, but again, there is a perception here that there maybe even a little bit of entitlement where they feel some of those assets should actually come down to them. And then the generation that most of these millennials parents belong to, the baby boomers, which again are a lot of folks on this call, they partially agree, not to the same extent. Only 36% of the baby boomers feel that an inheritance is a parent's obligation. So there is a gap there. Okay. But in general, this inheritance, this passing of your wealth to the next generation is something that's on people's mind. And for a lot of folks, it's something that they feel, they want to do to continue to help that next generation. So when we look at, planning, we have the right thinking. So when we look at Canadians, and again, I think these next two slides, it's a real eye opener. Okay. So number one, 91% of Canadians think wills are an important component of an estate plan. And I believe it is as well. Okay. And I'm going to talk a little bit about the importance of a will, the benefits, the drawbacks, and so on shortly. And for some of you that are on this call, you might say, oh, this is a topic that I'm already well aware of. Well, maybe, there are definitely aspects of a will that needs to be updated on a regular basis that perhaps through this conversation today, you may reflect and say, you know what, I need to go back and look at that will. Okay. 86% of Canadians think that appointing a power of attorney is an important component of an estate plan. Okay. I do too. And then the third one is 77% of Canadians think that it's important to talk to their healthcare providers, okay, about their wishes. And again, when you say healthcare providers, one a topic that is really important for all of us, but is very or is often overlooked is your health directives. Okay. So again, all of these numbers we're getting, anywhere from 3/4 to almost 100% of people saying, there are certain things about an estate plan that's extremely important. Okay. So this is the right thoughts, but let's look at reality. Okay. 70% of Canadians do not have an estate plan, which is mind-boggling considering how many say that how important it is. Okay? Less than 48% of Canadians actually have a will. So even though they recognize it's important, most of them aren't following through and actually putting one in place for their family. Less than 65% of Canadians have appointed a power of attorney. Okay, so again, there's a high percentage of individuals that recognize it's important, but they haven't done anything about it. And then look at this from a health directive. Even though almost more than 75% felt it was important, only 7% of the individuals that they had interviewed had said they had actually spoken to a healthcare provider or their families about health direction, which is mind-boggling. That gap is significant. And folks, I get it. This topic isn't the most exciting, but I'll tell you, it becomes important when something happens. That's when people tend to put it in place. When all of a sudden they have a change of health, or they have a change of situation in their family situation, they end up going out and putting all these in place. Okay, and they scramble around, and it's another thing that's really stressful. So really, what I'm talking about today is let's be proactive. Let's be proactive and try to get some of these in place. And again, it's baby steps. Start with one, and then move on to the next, and so on. So here are the most common reasons for not having an estate plan. Okay, number one, I do not have enough wealth. Most folks on this call have more than enough wealth to be putting this in place. And number two, I'm too young. Okay, I think this is something that especially with kids, having a will or a directive or what have you, I think is important, especially ones that are obviously age majority. So it's something that should be looked at. I don't have children. We have folks that have actually amassed a reasonable size net worth and they don't have kids. And then they just say, I don't need a will. Okay. But it's important because if you don't have one, the courts are going to decide on how those assets get broken down. And I don't know how to start. So again, we're here to help, with our families and with folks on this call to say, hey, here's what you need to do to kind of put one foot in front of the other and get the ball going. The next one, cost is too high. Folks, it's not overly costly to put some of these things in place. A will and a power of attorney generally get done at the same time. Health directives get done as well. It's just a matter of actually finding time in your day or in your week to actually book this and get it going. A lot of folks have an informal plan. They say, I don't need one. I don't need anything overly structured. My situation doesn't need it. So therefore, I'm just going to have an informal plan. I don't know where to get the advice. Again, if we're not sure if some of these ones are ringing true to you, then we need to have a conversation so we can actually suggest how to go about getting some of these things in place. I don't need a formal estate plan or a will. And then the last one is just another reason, just random. Okay. And I think part of it, when we go back, this is a great slide. Some of you that attended my last quarterly workshop, this is familiar. So I believe a lot of this is just poor financial literacy. So when you actually look at these, 5 points and you look at an individual that is indifferent, somewhat unfamiliar or very unfamiliar with some of these topics on the left-hand side, the numbers are stunning. So when I look at the first one where people, when they say, hey, it's expensive to put a will in place, if you look, 58% of them are indifferent or just are unfamiliar with what the cost really is. Okay. Legal fees, same thing. The number climbed. 64% of the individuals that responded said they had no clue or were indifferent about the cost of what legal fees are. Executor fees, 70% of the respondents, again, fell in that latter category. And then the probate process or probate fees, 72%. And then again, lastly, privacy issues, again, 72%. So when we look at just these topics or when we look at these categories, we're looking at almost 2/3 to 3/4 of the individuals that are indifferent on the cost or have no clue at all. So again, today is about getting informed. Today is about educating you folks about what you should be considering. Whether you apply these in your situation, whether you run out and do these things, that's a matter of opinion. And again, it's why you need to have a conversation and get some advice to figure out which ones apply to you and which ones don't. So again, estate plans can help provide tax efficiency. I don't know many folks that want to give extra money to the government or minimize their family share that's going to go to the government. Number 2, family harmony. Folks, this is a big one. We have conversations often where people will say, listen, I really want to make sure my family stays, intact or happy. When I pass away, I want to make sure that there's no grief or what have you. I want to make it as simple as possible. I don't want to have any rifts based on how I've left my estate. Okay. Speed. You hear a lot of folks, they talk about how long it takes the probate process, okay, or the estate process when someone passes away. Well, when you don't have your affairs in order, it takes even longer. All right. Control. I think this is a big one. So if you don't have some sort of formal plan, whether it's an estate plan, a will, a power of attorney, or what have you, then you're really leaving those decisions up to third-party individuals. And it may not be your wishes. And that's the unfortunate thing. And the last one is the peace of mind. Peace of mind knowing that your family is taken care of. Peace of mind that you know that your estate will be well looked after. So we're going to talk about some estate planning basics here. I would maybe argue that they're not basics just because of the percentages of people that are not doing these at this point. But we're going to go through them. Again, for some folks, it's going to be a reminder. For other folks, hopefully it's a little bit of an eye-opener about what you need to do to start getting things in order. So estate planning basics, I'm going to walk through with the most basic one to start is what is a will? Everybody knows what a will is. Essentially, it's a legal document that outlines how you want to distribute your assets. It's pretty simple, okay? And in this case, I have 6 points. Provide for loved ones, children, grandchildren. Decide who will get your home and property. I had a client years and years ago, probably a decade ago, and they made a comment, said, everybody that's age majority has a will one way or another. It's either a will that they drafted and provided direction, or they have a will that they're leaving to a third party, to the government, to the courts, or what have you, to determine how your estate is going to be broken down. So really, it comes down to, again, being proactive and outlining your wishes. There might be some folks that you don't want your estate or your assets to go to. Well, the problem with that is that, based on how the courts might see your situation, your assets may very well end up with those individuals. Again, by taking the time to formulate and document what you'd like to have happen, make sure that it gets to the folks that you want to have those assets. Okay. Clearly states out who should receive possessions. Listen, jewelry, vehicle, the intangible stuff, the jewelries and that. These are the things that I see most often, the keepsakes, where family members, again, can cause a little bit of tension because these are the ones that they have memories to. And there might be something that a parent or a relative or what have you that's really dear to them, and they're hoping to get, and maybe one partner or one family member takes it. And again, it can create some animosity, not only at the time, but also, a lasting animosity that carries over for years. If you have kids, who's going to take care of your children and your dependents? It's interesting. It's also, what about your pets? I know that sounds funny, but, we have a dog ourselves, and it's like a second child to us. If something were to happen to us, you want to make sure that they're well taken care of as well. And also, you have an opportunity to leave instructions for end-of-life ceremonies if you have some wishes. And, above all, it also names who can take care of your estate, your executor. Now, I had a conversation earlier today, actually, where somebody was saying, hey, my children, I was thinking about naming them an executor, but it's a big responsibility, which it is. And I don't really have a spot today where I've talked about executors, but, as human beings, we get better with experience. The challenge with being an executor, you might only be an executor 1 or 2 times in your life. So the challenge is you learn as you go through it during a period of time that's very difficult. So there are companies out there that will provide executor services, but to be fully transparent, there's not that many. There are lawyers that will actually provide executor services, but the amount of companies out there that provide it now, there's not that many. The banks used to do it. The banks have slowly got out of the executor business. It's a very time-consuming and low profit margin a business for them, which is the reason they've actually reduced it. They will support you, or they'll say, yes, we do it, but really they're just tapping into an estate department. They're not the actual executor. So we have done some due diligence. We have done some legwork for other clients. We can make some suggestions here. Okay. So what's the benefit of a will? Again, I talked about this earlier. Avoid delays in settling the estate. Post-COVID, settling an estate takes longer than what it used to. Because again, the courts get involved and so on and so forth. It just takes time to file all the proper documents and just get through the red tape. So if you can streamline it as best you can, things move quicker. Okay. Number 2, reduces administrative paperwork for your family at a difficult time. I just mentioned this. Again, provides peace of mind and clear direction about your wishes to your family and loved ones. And the last one is to reduce involvement in your private affairs. So again, some folks might have assets or their estate that they don't really want to be dug through significantly. So by having a proper organization done, it can actually minimize how intrusive it is into your situation. So here's a good question. What happens if you die without a will? Intestate is what it's called. Okay. So what happens is when you die without a will, you're actually leaving the decisions on how your property will be divided and distributed to a third party. Okay. And this is based on the province where you reside. So BC is a little bit different than Ontario and so on and so forth. But I put in a couple of examples here. So, maybe the situation is you have a spouse with no children. Okay. Maybe you have a spouse with children. You might have children, but no spouse or children, etc. And so if you happen to have parents that are living and you have kids, maybe it actually flows to the parents rather than the kids. So again, there is a breakdown that's predetermined when you die without a will. So when you actually start to look at some of those, you might actually want it to go to your kids rather than your parents if they outlive you. But again, if you don't have a will, then it's going to end up in the courts and they're going to make the decision. Okay. So the biggest thing, again, you want to document it and make sure that you have your wishes well documented so that you can actually have them left properly. So let's actually switch gears. So that's the will. Again, the will is probably the most basic piece. Again, a lot of folks don't have a will. So again, if you're sitting there and you're making some notes, then I would write down right now, look into will. Okay, number one. Number two is the power of attorney. So in BC, I'm going to focus more on BC law versus, if we have folks here from Ontario and so on. But again, there's two types of power of attorneys that deal with finances and property. There's a general power of attorney and an enduring power of attorney. Okay. Now, both of these types of power arrangements must be entered into while you're capable of making decisions. Okay. So I'll give you an example. For some of you that are on this call, you've heard me talk about my father-in-law. My father-in-law, kind of old school. My mother-in-law and father-in-law, we highly encourage them to put certain things in place. This is one of the things that they said, hey, you know what? We're healthy. We don't need it. Unfortunately, my father-in-law got struck, with an illness, and he wasn't able to put his power of attorney in place before he became incapacitated. To put it in place today is not overly expensive. By time we got to a situation where my mother-in-law wanted to, have more freedom, she wanted to sell the house, but she couldn't sell the house because it was a jointly held asset. So we had to go through the court process of actually getting him deemed incapacitated, and then setting up essentially the power of attorney in her name so she can actually sell the house. Folks, it took 7 months, 3 doctors, and about $7,000 to actually finalize that process. Okay. And once it was actually put in place, unfortunately, he passed away about 3 to 4 months later. She never ever, needed the power of attorney in hindsight. But again, she was out the dollars, and then she was just out the whole process and, the disturbing nature and so on and so forth. So again, a power of attorney today is something that is not overly time consuming. It's not difficult to generally make that decision, but you want to get it in place, especially if you're doing a will. You can do the power of attorney at the same time. Okay. So can your attorney, a power of attorney, make decisions about my health and personal care? So under a general power of attorney or an enduring power of attorney, okay, they cannot make medical or health or personal care decisions for you. Okay. So I'm going to actually talk a little bit about a representation agreement and advanced directives. Now, this is something that's a little bit newer and not spoken about as often. But it's again, I was having a chat last week with someone, and they said, what a great gift you can give your family by having these discussions and making some decisions, as opposed to putting perhaps a decision on the hands of the kids. Having them make really difficult decisions. So again, it's not for everybody, but it's something that we need to be aware of, because again, it's a powerful piece of the planning to say, hey, how do I want my health? How do I want my decisions to be made? Do I want to make them? Do I want to put that burden, if you want to call it, onto my kids or onto somebody else? So let's look at these two different things. Sorry, guys. So the difference between a representation agreement versus an advanced directive. So advanced directives will be followed by medical practitioners, provided that the document pertains to the situation you find yourself in. Okay, so again, there can be some gray areas. It might apply for one situation, but not everything. So it's a little bit more of a defined directive, whereas a representation agreement is more broad, which tends to be a little bit more useful. The only drawback to it is that, again, you're putting the decision with a family member, maybe one of the kids. If something were to happen to you health-wise, you're basically saying to that child, you're giving them that responsibility that says, hey, you know what? If something happens to me, I don't want to have, measures taken to keep me alive. Well, if you happen to have a couple of kids, one child might say, hey, you know what? They might be a little bit more pragmatic and understand and say, you know what? Your mom or dad, we need to make this really difficult decision. The other one might be a little bit emotional, might say, hey, you know what? Mom or dad, they're strong. They're going to come back. I don't want to make this decision. So now what you're doing is you're creating, again, this situation for the kids or for the family members to make a difficult decision that could ultimately fracture that family on a go-forward basis. For some of you might say, listen, I want to take that away and I want to provide a guidance based on my wishes, and I want to make sure I document them. Okay. So again, I've kind of talked about what is a representation agreement. Again, it authorizes an individual to make a wide variety of healthcare related decisions on your behalf. They can actually consult with any medical professionals before making any decisions and so on. Okay. A advance directive, again, is a document that's authored by you that sets out how you want to be treated near the end of your life. So you're making these decisions rather than, a loved one or what have you. So again, a health directive, should you have one? I think you should explore whether to have one. And again, it ultimately comes down to your wishes. But again, these are all things that are often overlooked, and it's not important until it becomes important. Okay, so I'm switching gears. So we've talked about the will, we've talked about the power of attorney. Okay, we've talked about representation agreements and advance directives. So now what I want to do is I want to talk a little bit about trust. Again, this is all about a good estate plan. So for some of you, this doesn't apply because you need to be 65 years or older. But an alter ego or a joint partner trust are very similar. Essentially, what it allows you to do is that you can roll non-registered assets, including properties. And generally, one of the benefits is you can do it at the market value. So there's no taxation to roll it in. And the benefit of it is actually it avoids probate fees. So now if you have a big estate, let's say you have $10 million of real estate. Okay, well, probate here in BC is 1.4%. So by doing this, you could save yourself $140,000 that would otherwise go to the government. Okay. Now, this is what's called that inter vivos trust. It means that it's a living trust. What it means is you set it up and you manage it through your lifetime. You got to file a return and so on. And there's a higher cost to do a trust like this versus, say, a testamentary trust that's written through the will. Okay. And that's something that I didn't actually cover off here, but I'll make some comments about it. So first, on the inter vivos trust of these two, because there's a cost, you want to actually do some calculations to say, hey, if it's going to cost me X to put it in place, how much am I going to save on the back end in fees, probate, and so on and so forth? So it needs to be financially reasonable to do it. Okay. The last 2 points, it makes estate administration easier because, again, these assets bypass the estate and probate process. And I think a big one too is for wealthy individuals, it maintains confidentiality because a trust document is private. Okay. Now, just before I get into this one, I will make a comment. There is another trust that I didn't write in here. It's called a testamentary trust. Okay. Now, this trust, unlike the inter vivos trust, is one that you write into the will as part of your direction. And what happens is that trust takes shape when you pass away. Okay. So you pass away and you leave assets in trust on behalf of your kids or your beneficiaries. The biggest benefit is you can control how that beneficiary receives the money. So the timing of it, how much, and so on and so forth. So for your kids, maybe you might say, hey, if you have younger kids, and when I say younger, older than 19 in BC, but perhaps younger than 30, they don't have the financial acumen to go out and manage a substantial estate. You might choose to leave some of the estate or some of the assets to them in trust so you can actually provide direction on the timing that they access it. Okay. So again, are all of these applicable to everybody that's on this call or every Canadian? Likely not. But again, you have to have these conversations to say what is reasonable, and then how do I go about putting it in place? Okay. So I'm going to switch gears here, and this is a conversation that I've been getting frequently, and this is talking about gifting with warm hands versus cold hands. Okay, so I'm going to talk here. So, and essentially, it's helping the kids. It's giving money away today while you're still living. And in a recent CIBC poll, 54% of Canadian parents say they plan to give a significant gift, early inheritance to their children or grandchildren. So what do you have to think about? Okay, so number one, you need to be generous to yourself first. You don't want to give away too much now and be short on cash or shortchange yourself in your later years. So again, keep in mind, one of the biggest expenses in retirement for Canadians will be uninsured medical costs. Okay, so uninsured medical costs today in most places, $5,000, $6,000, $7,000, $8,000 per month. All right. Now, again, back to my story. My father-in-law was in one of these long-term care facilities, and the BC government or BC Met, they actually took care of a good portion of it, but there was still above and beyond that my mother-in-law had to pay above and beyond. So again, when you're gifting, you want to make sure that we're looking at those financial commitments in the future. Number two, pick the right pace. It's not an all or nothing situation. You can give money a little bit today, a little bit next year, maybe 2 years from now. But again, you can do it at a pace that's comfortable for you. Okay. We also have to be mindful about the tax. So there are no taxes on monetary gifts for the giver or the recipient. However, there could be tax consequences depending on where you pull the gift from. So if you have non-registered assets, it's pretty simple. If you sell it and there's a gain, you're personally going to pay tax on that. But if you gift that money, you're not going to pay tax, and that the individual receiving it will not pay tax. If you take it from an RSP, obviously any withdrawal from an RSP or registered plan is fully taxable. And then others, make a plan. So having a solid financial plan that outlines your future income, cash flow needs, takes into account inflation and so on, is a very good exercise to work through if you're planning to gift to your kids, okay, or anybody for that many. So you want to make sure that, again, you're not shortchanging yourself. So gifting, again, is something that is happening on a regular basis. Again, it doesn't mean that the individuals on this call have to, but if you do decide to do it, again, you want to make sure it's reasonable for you. You want to make sure it's well documented. You have the right legal documents in place. If you're, maybe you want to give a promissory note rather than a straight out gift, because then you can control some of that money. Again, there's pros and cons to everything, but these are conversations that we're having on a regular basis. All right, so I'm gonna wrap up the basics of the estate piece. We talked about the benefits of a plan, the importance. We talked about the will, power of attorney, different trusts, directives. So now we're going to talk a little bit about what happens. What happens when you pass away? Okay, how are your assets taxed? So I'm going to do a case study, Paul and Maureen, we're going to call them, and I'm going to walk through how, again, it's a simple example. I haven't factored in everything, but again, I want to give you an idea of what it looks like. Okay. They have multiple assets and income streams. So they have registered accounts, RSPs, LIRA. They have a principal residence. They have a second property. So they have a family cabin in this case. If you don't have a family cabin, but this sounds like you and you have non-registered assets, taxation would be the same. Okay. They've done limited planning to date. And because there's a partnership, they will benefit from CRA spousal rollover on first death. So what I mean by that is there's a mechanism that CRA has that if you're in a partnership and you pass away, your assets can roll to the surviving partner or spouse on a tax-deferred basis. So I'll use my example. My wife and I predeceased my wife, Diana, and my RSP can roll over to her tax-free or tax-deferred. Okay. And when she passes away, that's when the tax will be paid. Okay. If I happen to have a non-registered account in my name, same thing. It'll roll over at the current market value, no tax. It's just deferred, right? Canada is very proud to say they don't have an inheritance tax, okay, between one spouse to the other. But really what they're doing is they're just waiting because they know they're going to collect that tax on the second person's passing. And so what happens is they will have, twice the value or a larger estate, therefore likely in a higher tax bracket. Okay. So let's look at this. So we're going to start looking at the second property. Okay. So here's the cottage or cabin that was purchased 20 years ago, joint with rights of survivorship. They bought it for $450,000. Now what they did is they did improvements capital improvements of $50,000. So folks, if you guys have second properties, okay, this is just a little bit of a best practice. If you're doing upgrades, capital improvements, or so on, folks, you want to make sure that that is well documented and you have proof that you've done that. And the reason why is if you do a renovation or what have you, and it's an approved type of improvement, you want to make sure that it increases your book value so your tax in the future is lower. Okay. I don't know if that makes sense. So if you bought it for $450 and then you did a capital improvement, in this case of $50, well, when you sell in the future, it's not off the $450, it's off the $450 plus the $50. So essentially it shrinks your capital gain because you put money into the property. For those of you that haven't been keeping track, I'm not sure how easy it is to go back and find some of that documentation, but it might be worthwhile if it was significant. Okay. So in this case, again, their ACB, their book value is $500,000. The fair market value of the property is $1.5 million. Therefore, the capital gain is the difference between what they bought it for, plus the improvements, minus the actual current value, $1 million. Okay. In Canada, based on today's income tax rules, only half of a capital gain is taxable. So of the million, only 500,000 is taxable. Okay. And it's taxable whatever the marginal tax rate is. Because this would push them up in the highest marginal tax bracket, I've used 53.5%. So 267,500 will need to be paid to the government on the last of them to pass away, or if they both passed away today. Okay. Now, one of the things to comment about was second properties. This is something that people don't always think about. For a lot of folks, maybe on this call, that have a second property within the family, your goal is to maybe leave it in the family. You want to have it passed down to the kids, okay? Because you have a lot of memories. The kids love it. Well, if that's the case in this situation, they would have to come up with $267,500 to pay the estate bill in order to actually keep that in the family. Okay. Now, if you have other assets, that's great. But if you have very minimal assets that don't cover that, then they're going to have to go and either get a loan, they're going to have to get a mortgage or what have you to make sure that they keep that within the family. Okay. With respect to the overall tax liability, okay, and I'm just going to talk about the registered plan asset. I'm not including probate fees and so on and so forth. So if you look at just the registered plan asset value of $1 million, that portion is 100% taxable. So the full amount, when you pass away, everything that you own is deemed disposed of. Okay, so if you have an RSP, it's deemed to be withdrawn the day you pass away. If you have a stock portfolio, everything is deemed sold for the purpose of tax calculation. It's not physically sold, but it's actually sold as though you've disposed of it all in one day. Okay, so in this case, a full $1 million comes out of the RSP, and the tax payable at 53.5% is $535,500. Now, I had somebody make a mention that marginal tax rate isn't 53.5%. You're absolutely correct. If you actually go from the minimal amount up to roughly 200,000, then it is above and beyond. In most cases, and I'm using this as an example, in most cases, when the last person passes away, you will benefit from the marginal tax rate at the beginning, but in the majority of your actual portfolio, your non-registered assets, your capital gains are going to be taxed at 53.5% because all of those assets come into your final tax return. Okay, that pushes you into the top tax bracket. So you will benefit on the first portion, but above and beyond that, you're going to be paying the top tax, the top amount. So, and again, to give you an example, my previous the cabin, maybe that's the marginal tax rate's a little lower, but here's an example where every dollar in the RSP would be 53.5% because you've already passed through all those different tranches of tax rates up to the highest one. Okay, so here's a situation where the government on a $2.5 million estate, and I'm not including principal residence. Okay, if you have a principal residence is deemed to be sold, but there's a capital gain exemption, principal residence gain exemption where you don't pay tax, but there is probate fees of 1.4%. So this 802,000 is likely a little bit light. But to give you an idea, that is the amount minimum that is going to be paid to the government. Okay, so the government's going to come along on $2.5 million to take $802,000, give or take. All right. So I'm going to pause there for a second. I'm going to get into minimizing CR ratio. So I'm going to talk to you a little bit about some things that can be done, especially with properties. I did a workshop, maybe about a year and a half ago about second properties, and I had about 7 or 8 different ways to minimize tax over the lifetime on properties in the event individuals want to keep it within the family. So I'm going to talk about some of those now, and then I'm also going to talk about one example that, again, is a high-level example. We give you an idea of the power of utilizing some strategies that are offered by insurance companies and so on. Okay. So when we look at, the estate, there's 2 options. There's do nothing, and then come estate time, CRA comes along, takes their tax. Whatever's left over is the legacy that goes to the family. And we've had some folks that have said, you know what, my kids, my beneficiaries are getting a lot of money. It doesn't matter to me how much money the government gets. They're already going to get a lot. I can tell you, in some cases that stays true to the end. But in a lot of cases, what I find is that individuals, as they start thinking about how their assets are going to be passing down to their family, they start to think about and say, hey, I don't want the government. I've worked hard for these assets. I don't want the government to get more than their fair share. So if there's anything that can do to minimize that over time, I'd love to do it. Okay. We've had people, 15 years ago, we had a situation where we had a client that we had family, we had the parents, we had the kids, and the parent, was not doing well. They were in the hospital, and the child said, "Hey, can we go and visit with my dad? We got to do some planning to minimize taxes." And just simply, you can't do it last minute. Okay. Some of these things have to be done along the way. So from a proactive point of view, from a family legacy, there are ways to reduce or pay tax along the way. And generally what happens, because you're actually starting early, you actually are leaving a larger family legacy to the beneficiaries. Okay. Now, every situation is a little bit different. That's why we have to dig through and have those conversations to figure out what makes sense. But there are ways, and I'm going to show you in 1 second, one option where I'm going to show how Paul and Maureen, cut their CRA bill. They reduced it by almost 60%. Okay, with some proactive thinking. So what can you do? Again, properties, non-registered, registered assets, and so on. Again, and I want to say, keep in mind, there's pros and cons with each. Okay, and every situation is a little bit different. So number one, this again goes back to when I did the workshop with the second property. So the first one, you can freeze the gains. You can analyze whether to co-own the properties or assets with your kids. Now, there's pros and cons with that. One of the benefits is if you co-own it with the kids, it actually bypasses the estate. The problem, if you co-own it with the kids, there could be some taxation issues, and you give up control. Because technically speaking, if the kids are a part of the account, they could technically walk into any financial institution and request that money. Okay. And they're required to give it to them because they're an account owner. Okay. The second thing you do is you can gift early. So gifting early, the reason why I have this in here is that anytime you dispose of anything, you're actually triggering some of the capital gains at that point. Okay. And that leads into the next one, capital gain diffusion. So again, you can dispose or gift over time. So let me give you an example. One of the things, if you have a second property, what you could do, you could have your kids on title and actually give them, say, 10% ownership or 5% ownership. Okay. So you're essentially gifting that to them. And what that does is it creates a tax bill or smaller tax bill today that you would address during your living years. And perhaps over, 10 years or what have you, you just gift more and more of that property. So at the end of the day, they're getting the property, you manage the tax along the way, and you've essentially, you smoothed out how much capital gain or taxation will happen over time. Okay. The third one, strategically withdraw from registered accounts over time. The reason why this one is relevant, if you happen to have lower income, the first 15,000 in Canada or BC, you can actually take out or earn as income and you don't pay any tax. It's the basic exemption rule. So if you happen to have somebody in your in the household and you're not splitting income or whatever, and it's actually really low, you could actually look at withdrawing some of the registered accounts early because there's limited taxation. And even if they're above that 15,000 or so, 15,000, there's still a threshold that you can actually start to draw down a little bit and pay some of the tax today, recognizing that you're going to be in a tax bracket in the future, when you convert it to a RIF. Number 4, you can implement a trust. We talked about those ones earlier. Legacy wealth transfer or estate bond. I'm going to give you an example of that in just a few minutes. Again, if you have a second property, you can make a decision on whether to designate it as your principal residence over the other one that you're living on today, because you can designate, one of the residents as a principal residence. And then the last one is if you have any philanthropic wishes. So you can utilize charitable contributions today or at the estate time to reduce tax in your lifetime, or again in the future. So again, for some folks, they might say, "Hey, I want to, maybe utilize my RSP, where it's a taxable entity, but I can actually, give that to a charity and get an offsetting tax deduction for the estate or for me personally." Okay. So I'm going to talk about this legacy wealth transfer, the estate bond. I got, I think, about 5 or 6 slides kind of left. So I'm just going to give this as a high level example. This is something where you actually use an insurance vehicle. Okay. And they call it all sorts, a legacy wealth transfer, an estate bond. But effectively what it is you want to use a permanent type of insurance. So a lot of folks are familiar with term insurance. Term insurance is something like, it's almost like renting your insurance. It's going to be less expensive in the early years, gradually going to get more expensive. And when you need it the most, it's going to be so darn expensive, you'll likely cancel it. So by having permanent insurance, there's two types. There's permanent insurance with a preset investment account. And then there's also permanent insurance with an investment account that fluctuates with the market. Okay. In this case, I'm going to show permanent life insurance using whole life. Okay. So number one, in these types, it gives you tax preferred cash value growth. The other one does as well. Inside a corporation, by the way, for those of you that have them, these are very advantageous. Okay. The policy is eligible to receive dividend payments. So not only does it have an estate benefit, it actually has an investment component that will grow over time depending on how it's structured. Okay. So here's 6 or 7 benefits. Tax sheltered growth within the investment portion. There's estate planning cash infusion. What I mean by that, insurance proceeds do not form part of the estate. So if an estate gets tied up for a year and a half, the insurance proceeds generally pays out much earlier and quicker than that. Okay. If you're worried about uninsured medical costs, again, it gives you the ability to access cash to offset potential expenses in the future. Again, we have to run the numbers. Allows family access to 100% of their liquid assets during their lifetime. So what I mean by that is some folks are saying, hey, I want to leave an inheritance. If you remember the statistics I gave you at the beginning, a high percentage of individuals want to leave money to their kids. Well, if you happen to have a vehicle like this that's going to provide a lump sum cash amount in the future, you can say, hey, I'm going to use all of my assets in my lifetime. And I know my kids are going to get something on a tax preferred or tax-free basis through a mechanism like this. Okay. The third, non-correlated asset class. Again, it's an alternative to traditional fixed income or stock market. There's tax preferred withdrawals. And again, the tax benefit continues to grow with the tax liability. So again, I'm just gonna show you here. So this is one through Sun Life as an example. There's a lot. There's ones through several different types, Equitable, Canada Life, and so on. This just gives you an example of the internal rate of return of the investment. The PAR account has been very similar to the TSX, just as an example. But when you look at it from a risk point of view, so risk standard deviation measures the volatility. If we actually look between the S&P and the Sun Life a dividend scale, you can see there's a fraction of risk within the PAR account versus the TSX. And we can see that here, even just in the last 25 years, the TSX, you can see here, has been up and down. And this is common with most equity markets. So let's actually look at it as an example. So going back to Polar Marine, again, their overall tax liability from the screen I showed you before was $802,500. Okay. So here's a situation where we can look at applying for one of these types of contracts. You apply as a joint last to die, which keeps your premiums lower. And the other benefit is the insurance company spreads the risk between two people. So they actually underwrite it as a joint age of 53 rather than two individuals that are 60. Okay. So therefore the cost of insurance is lower. In this case, we wanted to solve for a future need, and that worked out to be a premium of $16,541. So again, utilizing the other type of insurance, we could likely actually put that one in place for a more reasonable amount. Okay. So over time, immediately they get a death benefit, a guaranteed death benefit of $267,000. But as the cash value grows over time and is reinvested, we see this total death benefit grows over time. And after 22 years, which I used, average life expectancy in Canada is roughly 82. They have a cash value of roughly $550, and they have an estate benefit of $814,000, let's call it. Okay. So when we go through the numbers here, so again, the age 60 joint life, which is at age 53, the annual investment was $16,541, roughly $1,400 monthly. Again, if you have non-registered assets, this is a great way to diversify and just rotate some assets around from an allocation and diversification point of view. And then if we look at the investment over 20 years, again, they put in $330,820. They paid the premium, but the cash surrender value after 20 years is $491,455. So if we go up, here it is here, $491,455. $455. Okay. The tax-free death benefit at 22 years, again, roughly age 82 for both of them, $814,000. Estate tax payable is $802. So the difference that the family keeps is $483,179. Now, I know what somebody might say. They might say, yeah, but Wes, what about all the growth on the assets, within their account? It's probably going to be way more than $802,000. You're absolutely correct. But we're also don't know how much is going to be spent out of that over that lifetime. But you do have to do some projections. You have to do some projections on the assets. What is that going to grow to? And then again, we actually look at, one of these estate or legacy solutions, say, hey, can we match it so it grows somewhat at the same pace? And then just work backwards on what's the amount that they have to be putting in on an annual basis. Okay. So in this case, again, for that $802,000, they've only paid $330,000 to actually generate the amount of money needed to offset the taxation. So what they've effectively done is they've passed on to their heirs an extra almost $500,000. Okay. So again, is this applicable to you? Maybe, or maybe it isn't. But these are things that we could actually look at, do some number crunching, and say, yeah, you might want to look at this. Now, I should make one other comment about this. These types of arrangements you have to qualify for. So you can't just go to an insurance company and say, I want this. You actually have to qualify to make sure that you actually can qualify for this. And then again, at that stage, once they come back with an offer, that's when you'd review it and put it into effect. So, okay. So here, nine planning mistakes I'll go over. It's the last slide, folks. Again, some of them that we've already talked about. I'm at 53 minutes right now, so I'm a little bit longer than the 45, but bear with me, and then I'm going to open it up for questions. Feel free to actually start putting questions in right now. I already have a handful in here that I'll answer in a moment. So 9 most common estate planning mistakes. So number 1, not having a will or an estate plan. We've already talked about that right at the beginning. Okay. Number 2, for those of you on this call that have a will, the second most common estate planning mistake is having an out-of-date will. So it's always a good idea to go back and review it. Maybe your beneficiaries have changed. Maybe your beneficiaries that you were hoping to leave money to, you might have changes on. Go through it and have a review. Okay. Number 3, not being specific enough. Again, I think, if you say, hey, everything's going to go to A or B or what have you, but if there are certain things that you want to have happen, then again, make sure you diarize it, note it in your will, and be specific of how you want your wishes to be carried out. Number 4, failing to consider tax implications. So again, I'll give you an example. Non-registered accounts or non-registered assets are taxed much differently than an RSP. So you might say, hey, I have $1 million non-registered account. I have $1 million RSP, and I have 2 kids. One kid is going to get the non-registered account. The other child is going to get my RSP account. And you might say, hey, it's $1 million to each person. The reality is the RSP is going to get taxed at a much greater percentage than what the non-registered is. So you want to make sure to be keeping in mind the tax implications. The other thing is if you actually have wishes about some charitable wishes, an RSP is probably the better thing to maybe name as a beneficiary or a charity. There's some tax benefits versus using non-registered accounts. Okay. Not choosing the right executor. I talked about this one earlier. Okay. Not considering health or incapacity planning. I talked about the 2 different directives, representation agreement and the advanced directive. This is something that I will guarantee you, I would say only a handful of investment professionals are talking to their family about this. This is something that I had a recent conversation with some colleagues. And again, this is something that we will start talking about on a go-forward basis. Okay. Forgetting to leave an inventory. An inventory is pretty important. I have folks that say, oh, I was actually going through all my accounts and I realized I had this orphaned account at this financial institution with $10,000 or $20,000 in it. It happens more frequently than you think. So we're working on an estate planning guide right now. It's likely going to be out hopefully next week is the goal. And what it does is it's a way for our families to actually diarize where all their accounts are, what some of their wishes are, key numbers that you would call if something were to happen. So we want to work on this so that over time we fill it up so that you can use it for the kids, for your executor or what have you. So it actually gives a roadmap of your assets and your wishes in addition to the will and everything else. Okay. And the second to last is not thinking about your beneficiaries. So same thing, thinking about, do you want to still have the same beneficiaries in the will that maybe you created 5 or 10 years ago? Okay. Making sure that you have successor beneficiaries on TFSAs, if you need contingent beneficiaries on RSPs and so on. Okay. And then the last one is just not seeking professional advice. So there are some folks that will opt to kind of do it yourself method. They'll just say, hey, I can take care of it. It's really simple. Yeah, it's fine. But if anybody ever contests it, and not that anybody would, but if they did, you just want to make sure you're dotting the I's and crossing the T's. Okay. So with that, I'm gonna wrap up here. Again, thank you everybody for attending today. I'm gonna actually go through the questions. If you do have questions, go to the Q&A box, type it in. I have just a handful of questions that I'll go through right now. Let me just see what this one is. Oh, sorry. This one was just a comment that just said, talked about the conversation about overcoming procrastination. And that's actually maybe what I should have titled this a workshop or this session. So yeah, absolutely. So this education and planning, financial literacy, regardless of the topic, I think is excellent. I have another one here that talks about should I use a lawyer or a notary to draft a will? It's a very good question. Generally speaking, most folks will use a notary because of the perceived or the perception that they are less expensive. Okay. What I have found in more recent years is that a notary and a lawyer, a well-priced lawyer, are charging roughly the same, or it's very, very nominally different. Okay. Now, a notary, just so you're aware, even if you do save a few dollars, there's a reason why you're saving a few dollars. A notary cannot advise on trusts. Okay. So if you said to them, hey, should I use an alter ego trust, a testamentary trust, joint partner trust? What kind of trust should I use? They cannot answer that. Okay. So what I would do is I would actually have a conversation. We can introduce you to some lawyers. You can have a conversation with them and figure out if it's a good fit, if it's a reasonable cost, and then you can make the decision based on what you're trying to accomplish with your wishes. Okay. I have one here that says, what type of individual is needed to create a will or any of it? So perfect. That's exactly what I just covered off. So a will or a lawyer or a notary is who you want to talk to. I would likely defer to a lawyer just simply because they can have a more fulsome conversation in the event you want to actually discuss any trusts. Okay. Now I know there are a few people here that have U.S. ties. So they have, they're going to have dual filing. I didn't cover anything off today, but if you do have questions, feel free to send me something individual. We do work with lawyers that are very familiar with cross-border filing, cross-border questions. They have a whole department and so on. I know that might sound like having a whole department is another word for expensive. I think they're pretty reasonable. Again, it's always worth a conversation, even if you don't go down that path, just to do some due diligence. Okay. And then the last one that I had here as a question, and again, I touched on it, but I'll make another comment about it. But is it a good idea to leave it in the hands of my child? If your intention that your beneficiary, your main beneficiary are the kids, I think it's important that they are involved. It is their assets. It is their money. But again, it's a lot of work and it can be overwhelming. And not only is just being an executor overwhelming, but you're going through a very difficult period of time in their life. In addition to trying to figure out how to probate a will, they're obviously grieving a loss of a loved one. So I would actually suggest that you explore, both options. You both explore whether to name an executor that's a third party. There is generally a fee for that. Sometimes a flat fee. Sometimes they charge an hourly fee. But again, you're going to have to determine the value, what you feel is a good value for taking that potential burden off or away from the kids. And again, if it's a really big estate, you might say, hey, you know what, I'm going to leave it to my kids to save some costs. But sometimes the legal aspect of an executor might, benefit you in filing the estate in probate. Okay. So we covered off a lot of things today. We talked about estate basics. We talked about taxation. We gave you some examples. So just to summarize, listen, lots of information. You will get this session, this workshop. But that being said, the first step is having a conversation. If you really don't know where to start, pick up the phone, send me an email. We'll get you started on the right track. For those of you that have been working with us for years, every time we have a meeting, we talk about wills, power of attorneys, and the estate plan. It might not feel like it because we're asking about it and passing, but there are some folks that are on this call that do need to go back and do the will, and we will continue to encourage. But and let's be proactive. Let's not have an event in someone's life force us into doing some of this planning. Let's be proactive and get some of these things under the belt. So once again, thank you. Enjoy the rest of your Tuesday. Really appreciate you guys. And we will talk to you in mid-October for the quarterly update, which will send out some hold the date reminders probably in the next couple of weeks. Everybody have a great day. We'll talk to you soon. Thank you.